Appeal, part heard in the matter of the London Steamship Owners Mutual Insurance Association and the Kingdom of Spain and another.
May it please your lordships. I've had a word with my learned friend, Mr. Hancock, and indeed Miss Dilnot up to her, as far as she's pertinent. We really don't think that time is a problem.
Good.
We really don't. I am, however, going to be as short this morning as I can without failing to give your lordships the help that it seems to me that you may be entitled to. Not least because some of the things that I have mentioned and will mention today will have a knock-on effect upon what I will otherwise be saying in the jurisdiction points, and therefore what is said today doesn't need to be said on Thursday or whatever. So I'm very conscious that your lordships will have an eye to the clock, but at the moment we all three think that there is not a problem.
All right. Well, what do you want to do? You want to add a little bit on state immunity to cover.
I'd like to actually. What I'd like to do is essentially deal with 2 points that emerged from my Lord Justice Popplewell. One of which was essentially a new point in relation to Section 2. The other demonstrated.
The court is allowed to take new points.
I'm sorry?
I said the court
I'm not for one moment suggesting otherwise. Indeed. The other, it was a demonstration of the fact that I hadn't adequately explained our case and our position. And I'd like, if I may, just to clarify.
That's all right. Well, you go ahead and do those.
If that's all right. Certainly, having the opportunity overnight has allowed me to edit my notes and to look at the transcript and to see where I hadn't made my position clear. Now, and when I make my submissions, I'm constantly bearing in mind the indication, and it was only an indication I accept, that your lordship made yesterday about the need to develop the question of performance under 3.1b. I'm going to try to tread very gently on that, and obviously, depending upon where my learned friend goes, your lordships may invite further submissions or not when I reply. But the first point that emerged from my Lord Justice Popplewell's questioning of me related to the example that my lord gave of a case where there has been a declaration that a contract has been repudiated. For present purposes, it doesn't matter whether it's a declaration in arbitration or in court, but for obvious reasons, because of the intervention of the award in Section 66.2, it has a particular resonance in the present case, particularly in the light of Svenska. But my lord expressed surprise when you thought that I was submitting that a declaration that a contract was repudiated produced a merger which somehow made nothing else possible. And that was absolutely not what I was submitting, nor indeed do submit. And I realize that I have been very bad in expressing what our case is. There is a contrast between the case where a declaration is merely a statement of a fact or of the parties' relative positions, which is the sort of situation I think that my lord was envisaging. And on the other hand, a declaration which is a complete determination of the cause of action as presented to the court or tribunal. And they are two different sorts of declaration. And my lord's example was the former. Mr. Schaff's declarations and the declarations of the court under section 62 were definitively of the second character.
Well, I don't want to stop you so early in this exposition, but I'm not sure you're right in saying mine was of the first character. I had in mind simply a claim which only sought a declaration.
Yes, what, I'm going to show you a case which deals with that. It's a decision of the Court of Appeal earlier this year, I believe. And I just thought I'd try to show your lordship that what you thought I was submitting, I'm not.
Right.
But for the present purposes, what the declarations made by Mr. Schaff were definitively dispositive of the entire dispute as referred to him. Indeed, that must be the case advanced by the club, for were it otherwise, their section 18 would be patently bad, because Mr. Schaff would still have got...
Yes, well, that's the point you made yesterday.
I made it yesterday, but it was, the point is it was dispositive. It was a declaration of the club's non-liability in the absence of payment of the claim. Now, the way that the club has, the Court of Appeal, perhaps, in Prestige number, whatever it was, 2, characterised the dispute. It was topologically the same as if Spain had begun the arbitration and had it dismissed on pay-to-be-paid grounds. It's the same thing. They said there's a dispute as to whether there is a liability, and it doesn't matter who initiates the claim. That's why I say it's topologically the same. Now, the club wanted more than an award, simply that the claim fails and is dismissed on pay-to-be-paid grounds. What they wanted also was, by way of counterclaim, a declaration which they could then convert into a judgment so as to present an irreconcilable judgment in the event which was foreseen as a real risk that the Spanish courts made an order for criminal injury compensation under Article 117. It was premised upon the need for that. If there hadn't been that need, there wouldn't have been the utility, and then the declaration would not have been given. Now, as I say, it is as if Spain had sought relief and failed. They could still, according to the club, still have carried on in Spain, and that's why the club had the counterclaim for the declarations that they have. And that was the cause of action that was finally disposed of by Mr. Schaff on my learned friend's own case. Now, may I just mention to your lordships a passage in the transcript before Mr. Schaff, which is in the supplementary call bundle at tab 17. I'll just give you, if I may, the page references, because they are quite long and time would not be usefully spent me religiously reading them out. But if you could look at pages CB, supplementary CB, 334 to 338, I hope you will see the significance of the point. But I'm not going to read it out now, and I think you will, it's fair to say that you will be able to see the important passages.
Can you at least tell us what the point is?
Yes, the point is why Mr. Schaff was being asked for the declaration and what was in contemplation so as to provide utility for the declaration. Now,
And that's the point, that they wanted something to set up as
an irreconcilable judgment
if Spain produced a judgment
on
that came to be enforced.
on the very premise that Spain could and would produce a judgment in Spain, or of the Spanish courts, given that there is a distinction, which would then be potentially enforceable. It wasn't on the basis that somehow Spain and the states were being prevented by Mr. Schaff from doing that. It was for the purpose of providing an irreconcilable judgment, if that is the case. And obviously, an award was completely hopeless for these purposes because of the arbitration exception. That is why, almost instantly, the award was converted into the judgment. It was only by that mechanism that the club saw that it might be able to advance an irreconcilable judgment in the United Kingdom. Now, so it was, on the club's case, definitively conclusive of the relevant cause of action. And that's why, my lord, I say that form of declaration is different from the mere declaration of a statement of fact or a statement of the party's relevant rights. The example my Lord Justice Popplewell gave really brings to the fore the decision of the Court of Appeal in Zovarko. And I wonder if I could just briefly show you that judgment. I don't know if you know it. Or...
I don't know.
No, right. You seem to know all of the other cases I refer to, so I'm sort of comforted. It's in Bundle C, Authorities, Volume 3, and it's at tab 40. And it was, to say it's hot off the presses is not too far. It was the 5th of August 2021. Now, that was a case, if I may explain it briefly, of the issue of shares in a company upon incorporation, which were to be issued, a large number of them were to be issued to the Nazir, the defendant. And he took up the shares but didn't pay for them, as was stipulated. He said that the payment was made by way of the provision of shares in another company. And that was referred to determination by a court, deputy judge, who held that no, the payment obligation had to be satisfied by the payment of cash. It wasn't satisfied by the provision of shares. Now, one of the terms of the issue was that if shares were not suitably paid for, then they could be forfeited by the company. And indeed, they were, in due course, forfeited. The question was whether the payment obligation still remained. And then there was an action then, a separate claim, then by the company for payment of the shares. And Mr. Nazir raised the argument that the determination by way of declaration that had been made earlier on as to the fact that the shares had to be paid for by cash was determinative of the dispute, and there was a merger. Now, that submission was rejected, both at first instance by Mr. Justice Burse and in the Court of Appeal. Now, can I just show your lordship, I think, a couple of passages in the judgment of the Court of Appeal, because it was the paragraph 1, which is at tab 40, the judgment of Sir David Richards with the agreement of Lord Justice Warby and Lord Justice Henderson. There's the issue raised in this second appeal is whether the doctrine of merger, whereby a judgment on a cause of action precludes a new action for further relief on the same cause of action, applies where the judgment is for declaratory relief only. It appears that this is an issue on which there is no decided case, either in this country or in any other Commonwealth country. The current edition of Spencer expresses the view that merger does not apply in the case of a purely declaratory judgment, as have all previous editions. Now, the declaration that was made is it appears at paragraph 6. Claims came on trial before Mr. Griffiths, Queen's Counsel. Over 4 days, he gave judgment for Zovaco, finding that there was no agreement that the shares were to be paid up otherwise than in cash. By an order dated the 14th of November, he made declarations that the shares were unpaid and that Zovaco plc, having taken steps required under the Articles of Association, and Mr. Nazir having failed to pay the same, is entitled to forfeit the shares, the 2017 order. Now, that was the declaration that was made. It was an entitlement to forfeit. And then at paragraph 8, we see on the 11th of October, the present proceedings, the second action were issued claiming 36 million and interest. Permission was given to serve the claim form out of the jurisdiction, and then so on. And then paragraph 10, the application was made on 2 bases. The application to set aside service. It was said that the claim for payment of the amount due on the shares was barred by virtue of the doctrine of merger applicable as a result of the declarations made in the 2017 order, alternatively, and then there was reliance upon Henderson and Henderson. And the learned Lord Justice then considers the judgment below, the judgment of the Master below, and on appeal from to Mr. Justice Burse, and then the discussion begins at 21, which sets out at 22 the passage from the judgment of Lord Sumption in Virgin Atlantic, which is actually quite a useful place to find it, so it saves having to look it up, where Lord Sumption famously identified 6 different ways in which the doctrine of merger or doctrine of estoppel can operate on a cause of action. And then he refers also over the page to a judgment of Lady Justice Arden, as she then was, in a case called Clark, at paragraph 24. Once again, a very, very useful summary of the law. A note, paragraph 5 of that, just halfway down the page, merger explains what happens to a cause of action when a court or tribunal gives judgment. If a court or tribunal gives judgment on a cause of action, it is extinguished. The claimant, if successful, is then able to enforce the judgment, but only the judgment. And of course, that raises the question of what happens when the award is converted. That will come back at a later stage. Now, so you can see how the argument went. Can I take you, unless there are any particular bits you would like me to show you, one might just note in passing paragraph 32, which refers to the fons et origo of merger.
My eye lit on paragraph 28. I don't know if that's
28. Yes. A doctrine that prevents a party bringing a second claim to recover a remedy that has already been the subject of a judgment between the same parties makes obvious sense. Yes, and that's
well.
Yeah. Well, yes.
It's a contrast between remedy and rights.
Yes. would prevent a party from bringing a claim for an enforceable remedy. But here, at least in the context of the judgment claim and the arbitration claim, we're talking about a claim on the award, and then in due course a claim on the judgment, rather than the underlying. And I've already explained how those claims are dependent upon the establishment of an independent contract I would accept. But the distinction is between, I would suggest, the disposition of the relevant cause of action and taking it further. Can I take your lordship? As I say, if there's anything else that your lordships.
No, well, I'd read 28, and I'm not sure I read it quite the way you're
well,
doing, but I mentioned it really for the benefit of.
No. That's.
Let's go on. Yep. Where do we go next?
Yes, it's at 37. I think is probably the critical paragraph. At the moment, I've just been trying to put it into context. Well, I think probably I was just going to show you the one passage from King and Hall, which is quoted at paragraph 32, where the embodiment of in a judgment of an outcome, quoted, the quotation is quite a famous passage from Baron Park. There be a breach of contract or wrong done or any other cause of action by one against another, and judgment be recovered in the court of record, the judgment is a bar to the original cause of action. That's the original cause of action in the present case is that which is arising out of the award, of course, because it is thereby reduced to a certainty, and the object of the suit attained so far as can be at that stage, and it would be useless and vexatious to subject the defendant to another suit for the purpose of obtaining the same result, hence the maxim transit in rem judicatum. The cause of action is changed into a matter of record, which is of higher nature, and the inferior remedy is merged in the higher. And that's why this is in relation to the distinction between the claim on the award and then the claim on the judgment. Very important. But 37, which is where we... and this, I hope, will deal with my Lord Justice Popplewell's principal point that was put to me. A declaration is quite a different remedy from judgment for a debt or damages. It makes sense to speak of a merger of a claim for debt and damages into a judgment for the payment of a specified sum as debt or damages, so creating an obligation of a higher nature. And that's where that's picked up from King and Hall. The lesser right is merged into the higher. The same simply cannot be said of a purely declaratory judgment, which itself imposes no obligation, but only confirms the obligation which already exists. So a declaration, as he says, cannot impose any obligation other than merely confirming what already exists. And in the case of a declaration of non-liability, that is, as I say, necessarily dispositive. As Mr. Justice Burse aptly put it, I do not see how a declaration which declares to exist the right, which the claimant already had before judgment was given, could be said to extinguish that pre-existing right. It does the opposite. It is a declaration of a situation. It does not create obligations. And that, of course, is what the award action and the judgment claim action are both premised upon, that there is an obligation deriving from the declarations. We say that there is nothing that in the declarations which creates obligations. If anything, actually, it avoids, it does the very opposite by declaring that there is no liability in the absence of payment. So it's as it were, the dismissal of a claim rather than the awarding of a claim. And then if we go to paragraph 41, the Lord Justice says, on one matter I respectfully disagree with Mr. Justice Burse. While he considered that the application of merger to declarations would depend on the terms of the declaration, it's my view that the basis and development of doctrine shows that it has no application at all to declarations. Of course, depending on the circumstances of the case, the claimant who first seeks only declaratory relief may be precluded by the other principles designed to prevent abuse from bringing further proceedings. So there is no cause of action on a declaration. Thus, the award claim is founded upon a complete failure to appreciate the consequences of the declaration. And likewise, the judgment claim, because the judgment is the judgment of a higher nature, which is enforceable as a judgment. And in the case in point, enforceable by the club, because it's a declaration of non-liability, by the creation of what was hoped to be an irreconcilable judgment for the purposes of Brussels I or Brussels Recast. So I hope that deals with and clarifies my response to my Lord Justice Popplewell's question, because I really didn't have any difficulty with the point that was put by my Lord as to on the basis of the contract has been repudiated, but it's what consequences flow from it. If in the example given of a declaration that a contract has been repudiated, there is clearly then scope for a determination of the consequences of that, albeit that in our particular case, that would be in the arbitration before Mr. Schaff, not in a new arbitration, and certainly not in court. And therein lies my learned friend's...
It's my fault.
No, it's not. It's my fault.
I'm having difficulty in seeing how this helps you, and it may be that it's because I'm not really understanding the distinctions you're making. One distinction you drew at the outset was between a case in which the declaration disposed of everything which had been sought and other cases. I'm not sure that's a distinction that we're concerned with in this case, and it certainly wasn't part of my example.
My apologies.
The other distinction that you may be drawing is between underlying substantive rights, which are declared in an award, and then a cause of action based on a failure to comply with the award, which is a different set of substantive rights which are being relied on.
Yes.
And in the context, I understand the point you make on paragraph 37 about obligation.
That's in relation to section 3(1)(b).
But so far as merger is concerned, as I understood the point that was being taken, it is that there can't be an action on the award anymore because the award has merged into the judgment. The award was for a declaration as to underlying substantive rights. It has become a judgment in declaratory form as to those underlying substantive rights. And therefore, you seem to be saying that what has merged in the judgment so as to be destroyed are not the underlying rights, which this would make clear wouldn't occur.
Absolutely right.
But the cause of action for failure to honour the award,
correct,
which isn't the subject matter of the declaratory judgment at all. The judgment doesn't declare whether there is or isn't a right to bring a claim on the award. The judgment doesn't touch on that question at all. The only subject matter of the judgment is a declaration in relation to underlying subsisting rights.
The cause of action. Yes, I've obviously not expressed myself with the clarity that I would like and you deserve. The cause of action for failing to abide by the award was a cause of action which ceased to exist once the award, with its declaration, had embodied in a judgment. The obligation to comply.
That's the question. Why so? Not by the doctrine of merger, because it's not, the judgment is not concerned with the same cause of action.
Well, it is concerned with the cause of action in terms of enforcement of the award. It's if one says And one of the problems in this case is that the club has created, in a sense, its own problem by issuing 3 separate actions. 2 actions in court and 1 action effectively to proceed by way of arbitration. And it's my principal submission that 2 of them must be wrong, because if the disputes that were referred to are being referred to court are properly justiciable, then by definition the same complaints cannot be referred to arbitration. Alternatively, if they are properly arbitrable, then they can't be referred to court. Now, then as to the actions in the award claim and the judgment claim, they arise out of identical facts, and it's simply the characterization of the nature of the alleged obligation. And the alleged obligation was, while the award was extant, to abide by the award, so it is said. We say it's hopeless, but for different reasons. But once it was converted into a judgment, the only honouring or abiding that was then legally due, if any, was that to the judgment. So it's essentially a point that there are currently 3 actions, 2 of which are irreconcilable with the 3rd. It's either justiciable or it's arbitrable. If it's justiciable, then it is by definition not arbitrable. If it's not arbitrable, that knocks the section 18 out. If it's arbitrable, then that knocks out the other 2. But even if that isn't the case, which I submit it is, then the claim on the award and the claim on the judgment are effectively seeking the same remedy for the same matters which are said to be wrongs, and you've got to simply then to identify the nature of the obligation. And the obligation, if there is one deriving from a declaration, ceases to derive from the award and then derives from the judgment, if that is the case. So it's as I say, it's really trying to identify what is the obligation deriving from the declaration. And it's important in this context, as I think I said yesterday, well, I'm sure I said yesterday, the present claim is a development of the obligation said to derive from the award, in due course the judgment, because by definition they didn't exist until the award or the judgment was actually issued. But it's a development of the cause of action which had otherwise been submitted to Mr. Schaff. Now, for that reason, it's properly justiciable, but it's not arbitrable. But if it's arbitrable, and Section 18 is the appropriate one, then justiciability, I would respectfully suggest, is inconsistent and cannot be maintained. I'm hoping that in answering my Lord's, or trying to deal with my Lord's question, I hope I've clarified that I'm not saying that a declaration necessarily merges so as to knock out other remedies claimed. It depends upon the circumstances. In the present case, because it was a declaration of non-liability, that was the end of the dispute. Per contra, if there's a declaration of liability in a particular sum is held due, then that would be different. But what I'm asking your lordships to do is to stand back and say, well, are all of these actions, the judgment claim, the award claim, and the Section 18, are they all internally consistent? And I would respectfully suggest they aren't. Could actually end up with irreconcilable judgments emerging from the award and the judgment. Out of identical facts. Identical facts. but I thought it right that you should see Novaco, because it is a recent judgment of this court and does pertain particularly to the point that was...
Yes,
I hope that's
it seems
fair.
to decide what I was struggling to articulate.
Yes, well,
Is it
that's...
perhaps inadequate.
I completely endorse that. And I hope it shows why I was not actually trying to say that any different result eventuated. But I'm trying to show that in terms of the analysis, it's why the claim on a declaration doesn't generate obligations. It generates a particular state of facts, which is then available for determination by the proper tribunal. So I hope, in fact, that my lord and I are now on the same position, and I hope I've made my position clear that I'm not saying that a declaratory judgment merges pre-existing causes of action. It may be different, of course, when one is converting a cause of action on an award under Section 66, but that's arguably different. But here, Mr. Shaft's award was definitively dispositive. My learned friend, Mr. Hancock, must say that. But it's a declaration of non-liability rather than liability, and that's why they needed, in effect, the counterclaim in the arbitration.
Right.
I think I've probably made more of a hash of that than I intended, but...
Is that it, or is there now a...
Well, there is there was one other point, and that is, I say that because there is no obligation emanating from the award or the judgment, which is in fact actionable at all, this is a serious issue to be tried, and because there is nothing to be performed, that knocks 3.1b out. That leaves Section 18 application, and I think actually what the states wish to say about the judgment of Mr. Justice Henshaw is something that I've already developed, and I'm not going to repeat unnecessarily. The essential point is whether the states positively and recognisably agreed that the clubs knew, and on the club's own case, by definition, independent claim should be determined by arbitration. And it's not a case of the deemed arbitration agreement deriving directly from the conditional benefit principle and actually necessarily from the state's failure to prove the satisfaction of the condition precedent of their right, and thus their failure to prove the existence of their right in English law at all, but a new and distinct agreement by which the states might be exposed to a liability in damages to be determined in arbitration. And you will hunt high and low before you can see any agreement that that claim by the club for damages based upon a liability of the states was agreed by the states to be arbitrable. And it simply cannot be that the conditional benefit burden in inverted commas can apply to the alternative claim by the club. You would ask yourself, has Spain agreed that the club can bring a damages claim against it? And you will, it's not for the court to create agreements. It may be for the court sometimes to infer agreements when it is clear that it should be inferred, and we know the fairly close limits on the inferring of agreements. And one thinks of the Aramis, famously, I think, argued by Mr. Hamblin. where you can only infer an agreement if there is no alternative analysis possible. We haven't put the Aramis in the already overburdened list of authorities, but it's well known as a principle for inferring contracts.
Can I just test that a bit? What the Act provides is that an arbitration agreement means an agreement to submit to arbitration present or future disputes.
Yes.
That means that the party agrees that any such disputes will be definitively determined by arbitration and that they will not seek to pursue them elsewhere.
When one's talking about direct contracting parties, because there is a distinction. Can I answer by reference to direct contracting parties? Just a contract between A and B with an arbitration clause. Yes, that is true. But if A commences proceedings elsewhere than an arbitration, let us say proceedings in court, then the remedy to B is to rely upon the arbitration clause as is proper and reasonable. He doesn't have to. He may just say, well, I'm quite content that it proceed in court. That would be the case with applying Section 4 of the 50 Act and Section 1 of the 75 Act and Section 12 of the 9 of the 96 Act. So it's, in answer to your Lordship's question, it provides the party wishing to rely upon the right to arbitrate with the opportunity to seek an appropriate remedy, which is not quite the same thing.
Well, if two parties take a matter all the way through a London arbitration, and there is an award, and one of those parties goes and commences a fresh set of proceedings in another jurisdiction on the same cause of action, plainly you might be able to take some steps based upon the award you have, but why can you not say that is a breach of our agreement? You agreed that we would arbitrate this dispute. And it's been definitively determined.
Because it's been definitively determined that the result is no liability, let's say. It doesn't mean to say that you cannot, by another route, seek a determination of liability. It may be that it isn't enforceable in England.
I'm sorry, I'm struggling with this. So if a losing party to an arbitration then goes and seeks to commence proceedings in another jurisdiction, that isn't a breach of the arbitration agreement.
Well, he is by definition, the example you've given me, he's honoured the arbitration agreement by going through the arbitration process.
No, but he's agreed that the dispute that he's now sought to revive in the foreign jurisdiction would be submitted to arbitration.
And the answer then is in the foreign jurisdiction for the party who has won in arbitration to say, this is res judicata.
Well, it might be, but why can't he also say this is a breach of contract?
Well,
why can't he? That's the basis upon which one obtains anti-suit injunction.
Yes, that is the basis. The basis on which one obtains an anti-suit injunction between contracting parties, that is true. Yes. When one's talking about a conditional benefit, which is essentially one stage removed. Now I'm going to come. Yes.
Up till now, I thought we were talking about.
We are.
A simple.
Yes. My problem is that in answering.
Do you accept my proposition as regards?
I would accept your proposition. I would accept your proposition as generally correct. And there are.
Well, that's good enough.
If that's good enough. But when one is talking about non-contracting parties...
Well, I think one just does need to delve into this a little bit. Mm-hmm. Because the way the Act works, as you pointed out in section 82.2, is it says it references in this part to a party to an arbitration include. What That doesn't mean it's, as it were, only for the purposes of part. What it means is that it's for the purposes of working out what the provisions in that part relate to.
That's not what it says, with the greatest of respect, my lord. What it says is, for the purposes of Part 1, party includes somebody who's claiming under or through.
It doesn't say that. It doesn't say for the purposes of the part. It says references in this part include any person.
Yes.
So when it's referring to a party to an agreement in this part, it includes Spain.
Somebody claiming under or through. Yes.
So you have to look at references to a party into an arbitration agreement and read them as though they include Spain.
Correct.
So there's no limitation on its application.
Well, what you can't know, but the point I'm obviously making the point very badly. You have to find as a fact that there was a distinct agreement by Spain to arbitrate the club's monetary claims. That's what you've got to find as a fact, and because of it arising as a matter of.
Well, that's a different point.
No, it's absolutely, it's not. It's precisely the same point. I'm sorry if I've not made that clear. References to a party include in Part 1 include a person claiming under or through. But you have to say that there was an agreement for the purposes of Section 9 of the State Immunity Act. There was an agreement by Spain to arbitrate the dispute, which is encapsulated in the club's monetary claim, i.e. to arbitrate questions about Spain's liability.
I understand you say that's a further point. I answered your first bedrock point, which I was just testing.
Yes.
Is that effectively Spain isn't to be treated for all purposes as a party to the arbitration.
And that I do say that.
And that's the point
yes,
I just wanted
but,
to test out with you.
And that's, yes, I mean, the only way that Spain became in any way subjected to the Arbitration Act application, which was then under Section 66.
Was because it says so in 18.
Yes, well, exactly, that's right. But you have, that's a different question from whether Spain has agreed to submit to arbitration a claim against it. And that's a new separate contract. By definition, it doesn't arise under the conditional benefit principle, which by definition has already failed because the contingency of the right has been shown not to have been satisfied. So you've actually got to find, as a fact, on the balance of probabilities, not serious issue, that Spain did in fact agree to submit the club's monetary claims to arbitration. And I would respectfully suggest that there was certainly no express agreement, and you can't imply an agreement because there are many explanations of Spain's conduct which are inconsistent or not necessarily consistent with the implication of such an agreement. And it must be a separate agreement.
And in the context of the Section 18 claim, how do you put it that this arises?
I say that there is no agreement. And thus, well, I say there's no agreement for the purposes of Section 9, and I also say there is no actual arbitration agreement in existence which can justify the making of a Section 18 order. Because it's an arbitration of a dispute in relation to the club's claims, which by definition only arise after the condition precedent
Claim
is
under
not.
Section 18 is for the appointment of an arbitrator.
Yes. But if there's, and there has to be, for that, there has to be an arbitration agreement. If there is no arbitration agreement in existence, then Section 18 is not possible.
Well, there can be an equitable obligation to arbitrate.
Oh,
which is not an agreement,
No.
but is something which has the same effect.
Well, that may be right. And that's if your lordships.
As in the J. Bowler, as in West Tankers, as in
Well,
any
no.
number of cases.
The J. Bowler gives rise to its own. It was dependent upon the existence of an equitable remedy of an injunction. Now, I've shown you Section 13 of the State Immunity Act, but it is a separate, it is an agreement which is inferred that Spain will make its claim for the asserted right in arbitration. Now, the asserted right, by definition, has now failed to be proven. Must be, because the condition a precedent to the existence of the right has been found not to exist by Mr. Schaff and, in due course, by the court. The contingency of the right has failed, therefore there is no right, therefore that explodes the right. Now, what you have to do is to say that having failed to prove its right, Spain also agreed to submit to arbitration a dispute about the mechanism of achieving that result. And that is a very different thing. So, with respect, it's an analysis which the J. Bowler can justify if you don't think very hard about it. As soon as you think hard about it, it doesn't work, because the contingency has already failed and the right has not existed.
Well, not thinking very hard about it, it sounds to me like what you're saying is that lucky old Spain, now that Mr. Schaff's arbitration has got the obligation to arbitrate out the way, it can now go off and do what it likes in Spain, and the equitable obligation which required it to arbitrate its claims in London has vanished in a puff of Mr. Schaff's pen. And no longer exists.
Well,
doesn't sound very.
Well, with the
sensible,
greatest of respect, you have to ask yourself what disputes were referred by the club to arbitration by Mr. Schaff. It was up to them what disputes they referred. They chose to refer the dispute which generated a declaration of non-liability. They wanted that declaration of non-liability to be embodied in a judgment so as to defeat any claim for enforcement of any contrary judicial result. What they didn't say, and they didn't seek, was a declaration that Spain shall not take any proceedings further in Spain. And of course, that would have been impossible because of Section 13 of the Act. So they got the declaration. You say, lucky old Spain. It doesn't mean that on the premise that you've given me, it doesn't mean that the claim on the judgment claim is not justiciable. Fine. I mean, this is the essential point that I was making, is that the three actions that the club has seen fit to commence sit very uncomfortably with one another.
All right, well, I think we've got that point.
Yeah, well, it doesn't surprise me that you have. But
Justice Henshaw said that Section 18 is simply a gateway, and it's really for the arbitrator to decide, in the first instance, their jurisdiction, whether the claim falls within the arbitration agreement, and then subsequent issues of jurisdiction. And what's wrong with that approach?
Well, but for the intervention of immunity, state immunity, there wouldn't be any problem. Of course, if it's up to the arbitrator to decide his own jurisdiction, then he could be challenged by a Section 67 application. Yes, but that would entail effectively compelling Spain to submit to the jurisdiction of the court, as was held in Prestige number 2, to be a Section 2 step in the proceedings. So you can only get to the stage of saying that that's appropriate. If you've otherwise concluded there is no immunity, once you've concluded there is no immunity, then that is a perfectly appropriate position to adopt.
But I asked you a few minutes ago, is what were you saying these points were relevant to? And my understanding was you weren't just saying it's a matter of state immunity. You were saying it's more fundamentally a question of whether there was an arbitration.
Yes. No, I am
saying is that Mr. Justice Henshaw, his primary position, his primary decision was that's not for me to adjudicate on. Now, are you appealing that?
No, we are not.
I rise simply to make sure that there's no misunderstanding. Mr. Justice Henshaw held in the context of state immunity that there was an obligation to arbitrate. In the context of the Section 18 application, then it was unnecessary for him to decide, because normally speaking on a Section 18 application not involving a state, then it is sufficient to show that there is a good arguable case that the tribunal has jurisdiction. But because of the involvement of Section 9 of the State Immunity Act, then the judge decided that he should decide on the balance of probabilities and with finality that there was an obligation to arbitrate which extended to the club's claims against the states.
Absolutely. I think my learned friend has very fairly identified it. I mean, one of the problems in this case, with these cases, is the interaction of immunity with the substantive relief claimed. And there is an overlap. And on occasions, I fully accept that I have I've trespassed into the jurisdictional matters, but I am not. What my learned friend has said is absolutely correct. I think
As I understand your point, it is that Mr. Justice Henshaw decided on the basis of the width of the arbitration clause, and that it was wide enough to cover the dispute which was to be referred to arbitration. And you are saying, whilst that would be a legitimate approach if you were dealing with two original parties to an arbitration agreement, the nature of the equitable obligation to arbitrate is that it's a condition of asserting a claim, and that only goes as far as an agreement to submit to arbitration the claim which you are asserting.
I'm really comforted that your lordship has got my fundamental submission, because I sometimes think I may have rendered it more obscure. You're absolutely right. And it's not right to start with the arbitration clause and say, oh, it's a wide arbitration clause, especially in the light of Fiona Trust. What you have to do is to say, was that the arbitration clause which was embodied in the relevant arbitration agreement which is deemed to have arisen?
Well, you'll have to say, was that a dispute which comes within the equitable obligation?
Yes. Was that a dispute?
Arbitration by virtue of the exercise of the rights in Spain, which trigger a conditional obligation? That's what I thought.
Yes.
That you were simply saying the only extent to which the states have adhered to or become bound by, or whatever expression you use, the arbitration clause in the policy is by virtue of asserting the proceedings in Spain. That, under the J. Bowler analysis, involves an equitable obligation to arbitrate. But if you ask to arbitrate what, it isn't everything which is encompassed by the arbitration clause. It is only that which is necessarily the corollary of the assertion of the right which is subject to the arbitration.
Absolutely. It's sometimes, as you will remember, counsel say, your lordship has put it so much better than I could have done. Actually, you just have.
That may stick in the gullet, but
well, it won't stick in mine. You have. I mean,
anyway, that's how I'm understanding. That's how I'm understanding your argument. That's
absolutely right. Absolutely right. Now, as for the particular issues before Mr. Justice Henshaw, we won on Section 2, we won on Section 3.1b, and the points on Section 9 and 3.1a, I think I've already developed. they're in the skeleton argument, and I'm not sure I can take it very much further. As you see, Mr. Justice Henshaw referred to benefit and burden, and I've made my submissions on that. But the second point that arose from the points made by Lord Justice Popplewell relates to the issue of submission in Section 2 of the State Immunity Act. Can I just refer you to paragraph 82, sub 3 and 4 of our skeleton, where I think our position is set out rather clearly. I'm sure Mr. Hamblin did it, so I'm sure it's done much more clearly than I did. Significant involvement. Page 33, CB/29. And this is in relation to what one might call the submission to the jurisdiction by way of counterclaim in the enforcement proceedings, or rather, by way of bringing the enforcement proceedings, and then that amounts to a submission to the jurisdiction in relation to the claims otherwise brought. And I think there's a reference to Christophe. And can I just give you the...
I'm so sorry, I'm not at the right page.
I'm sorry, it's page 23, in internal page 23, paragraph 83, sub 3 and sub 4.
Page 29, my lord, of the call bundle.
Yes, I think
Yes,
you may
please.
have different pagination from us, Mr. Young. But anyway, it's page 29 of the call bundle.
Oh, I don't know how that... Well, yes, I think there have been various versions of amendment, and I think I've probably worked up.
It's in fact my internal page 24, but it doesn't matter. Paragraph 82.
Oh, well,
I've got it now.
Got it there. That's a start. And the point made at 3 is that the club could never have brought counterclaims in Spain's enforcement application because the registration proceedings were governed by Brussels 1 and the old Part 74. The importance of Part 74 will appear from the case that I'm going to refer you to, and didn't permit such claims to be brought, since Brussels 1 requires effectively automatic enforcement. And the way it works is that you seek enforcement, and the party against whom you're enforcing then issues his own appeal against that enforcement. But there is nothing that... it is illegitimate, effectively, to undermine the processes of Brussels 1 and Brussels Recast by effectively allowing a party to do nothing, to wait until enforcement, to say, yeah, you've now submitted to the jurisdiction, we are now going to bring our separate claims against you to defeat your claim for enforcement. And we're going to do it by way of claim, a separate claim, but it's going to be sufficiently close that it's a counterclaim that's going to defeat your enforcement. That is absolutely contrary to the whole edifice created by the Brussels regulations in their various forms. It is the absolute nemesis of the automatic enforcement. And there is therefore no submission to the jurisdiction by issuing enforcement proceedings, which can then be relied upon as founding a jurisdiction and necessarily a lack of immunity in this case. And we refer to Christophe. That's a judgment of the Court of Appeal. It's at Bundle A, Volume 3, tab 38. That was a judgment of the Court of Appeal on appeal from Mrs. Justice Andrews. And if I can just briefly tell you what it was about.
It looks to me as if that case supports the idea that registration is intended to be swift and efficient, and therefore you shouldn't extend time limits, but it's actually got nothing to do with counterclaims.
No, that's right.
So,
but it's...
the way your subparagraph 3 is phrased, which might suggest that the case is about counterclaim, claims is not quite right.
No, I would agree with that. But what it shows is the Court of Appeal, and particularly the judgment of Lord Justice Gross. I'm assuming from what your lordship has said that you're familiar with Christopher.
No, I'm not, but I looked
Oh,
up
well,
while
it's...
you were speaking. And
Sorry?
No, but I'm not, but I looked up the citation while you were
right.
speaking.
Oh, well, that
seems to be what it says.
It's in Bundle A. Authorities
Do we need
A.
to go to it? I think you accept it. It isn't dealing with counterclaim.
No, but what it is, it's not dealing with counterclaim, but what it is dealing with is the use or the abuse of domestic procedures to undermine the enforcement. And we say it is simply relevant in considering whether there has been a submission which can undermine the position of the party seeking enforcement. But I agree, it doesn't. It's only about, on its facts, only about whether the general extension of time provisions in the CPR applied to an application under CPR 74, which is specific to Brussels. And we say it would be completely counterintuitive to say, well, anybody who enforces a Brussels judgment will necessarily submit to the jurisdiction so as then, in relation to a completely different claim, can be met by a claim against it and the assertion that it has submitted to the jurisdiction of the court by issuing its own enforcement proceedings, which, now, in the old days we might have had a reference to the CJEU, now we can't, so your lordships will have to decide that particular point of European law, but you have to do it from the perspective of the application of European law as it existed before last December the 31st. And that, therefore, the issue of enforcement proceedings in relation to the Spanish judgment was not a submission to the jurisdiction of the court in relation to any of the other proceedings, and thus Section 2 does not apply. There may be other, I fully accept, there may be other exceptions which apply, whereby the states lose immunity, but Section 2 doesn't help. And the next point is actually quite a useful case. It's for SME investments, and that is Bundle A, or Authorities A, Bundle 2, Tab 22. It is itself quite useful in that it sets out the test of would a disinterested bystander have concluded that Spain was submitting. And that probably is just worth showing you because it's a nice summary. It's A2 tab 22. It's really at page, para 41, where Mr. Justice Patton, as he then was, cited a passage from Mr. Justice Coleman in an otherwise unreported case, who then, in turn, relied upon what was said in the Messiniaki told me and the Astro Exiteo case. And it's about halfway down at G. A useful test was whether a disinterested bystander with knowledge of the case would have regarded the acts of the defendant or his solicitors as inconsistent with the making and maintaining of his challenge. And that's the test that's been applied. And it's just another version of Lord Justice Mackinnon's official bystander in some ways. But you have to ask yourself, was Spain's issue of the enforcement proceedings necessarily to be taken as a submission to the jurisdiction of the courts in relation to the other claims? And particularly when the award claim was issued before the enforcement proceedings, it's very difficult to see that it was. But, my lords, I'm being reminded by Miss Dilnot that I've already gone on too long. Unless I can assist your lordships further, the I hope everything is set out in our skeleton argument, and I'm sorry I've been as long as I have this morning. Do apologise.
Thank you very much.
Thank you.
Mr. Young. Before we call on Mr. Hancock, I should ask you, Mr. Not. Mr. Young took what I think he accepted was a new point relating to the definition of commercial transaction and sought permission to rely on that. Do you make the same application on behalf of Spain? France?
On behalf of France?
France,
my lord, yes, I do. So to the extent that...
So you effectively adopt what Mr. Young said?
Indeed I do. So to the extent that the court accepts it, then France adopts it as well.
Yes, all right. Great, thank you very much. Yes, Mr. Hancock.
My lords, I'm going to try, if I may, during the rest of today, to concentrate on state immunity rather than going down any of the highways and byways that relate more properly to the territorial jurisdiction. And in relation to immunity, then I'd like to make a few introductory comments before making a few further background. It may be helpful for your lordships to have a brief overview of the club's position in relation to immunity. And the first point I should make, and perhaps the most important point I should make, is that it is important to bear in mind the activity of which complaint is made by the club. As your lordships said on a number of occasions yesterday, the activity is the state's pursuit, particularly their continued pursuit of their claims pursuant to the insurance contract in the Spanish courts. That activity was carried out in breach of the obligation to arbitrate, which had been established in the arbitration proceedings in front of Mr. Schaff and in the court proceedings in front of Mr. Justice Hamblin, as he then was, and in front of the Court of Appeal. And your lordships will remember that Spain and France participated in those court proceedings, and indeed the Court of Appeal, with Mr. Justice Hamblin, found that they had voluntarily submitted the question of Mr. Schaff's jurisdiction to make those decisions to the decision of the English courts. So they argued the points fully. They argued the points fully before Mr. Justice Hamblin in a 7-day trial. They argued the points fully in the Court of Appeal in a 2-day trial. And both Mr. Justice Henshaw and Mr. Justice Butcher understood and accepted that the activity of which we make a complaint, and obviously this is principally relevant to section 3.1a of the State Immunity Act, was the pursuit and continued pursuit, and I emphasise continued pursuit, of the claims in Spain. Secondly,
Sorry to interrupt you. I had thought that your claims, the award claims and judgment claims, related exclusively to conduct after the award and after the judgment, respectively, in Spain. So when you say it's the pursuit and continued pursuit,
yes, you're quite right. It is the continued pursuit.
it's solely the continued
in
pursuit.
relation to the award and judgment claims.
Yes. Thank you.
The logic of that obviously being that the award set out the position as at that moment, albeit that it was declaratory of the position as it already stood. The judgment confirmed the award on that. The third limb, that is to say, the obligation to arbitrate, relates back, as it were, both to the original obligation to arbitrate and also forward to the obligation to arbitrate, which continued to bind the states throughout the time that they were in fact litigating in Spain. The The second point that I would make, my lords, is that it had been accepted by the states up until yesterday that this activity was not a sovereign activity, but was instead a commercial activity. And that had been accepted by the states not merely during the course of this litigation, but in the course of the litigation in 2013 and in the course of the proceedings before Mr. Justice Hamblin and before the Court of Appeal. The suggestion made yesterday for the first time before your lordships, which, as your lordships have indicated, is not actually a point taken in the grounds of appeal, nor actually in the skeleton argument, is a suggestion which is wholly new, and I make clear, object to that point being taken now, after all these years. It's not even clear to me what the point is that is being taken now. As I understand it, then Mr. Young's submissions, what he is relying upon is effectively some sort of application of the aestum generis principle under section 3.3c, so that the only types of non-sovereign activities that fall within the section from immunity are the four classified, bracketed types of activities. Even there, what Mr. Young says, as I understand it, is that the activity that he relies upon here is the judicial activity. In fact, it's quite clear that the claims of the states before the courts of Spain were not judicial activities, any more than the claims of the 265 or so private parties who brought claims. These were not the subrogated parties, these were individual parties who also brought claims before the courts of Spain, and whose claims could not conceivably be described as sovereign or judicial. The fact that claims are being heard by judicial authorities does not make those claims judicial.
If claims are brought by way of prosecution, though, by a prosecuting authority,
well, again, my lord,
that might be different.
They weren't, as a matter of fact. And again, you have to be a little bit careful here, because there is actually a dispute in the arbitrations and the underlying actions as to the nature of the proceedings in Spain. If I can summarise my hope uncontentiously, then the position in Spain is that Spain brought and France brought their own claims. The public prosecutor in Spain is under a public duty to advance the interests of parties, including by bringing claims on behalf of those parties, unless those parties waive their claims or reserve the right to bring their claims in civil proceedings. I should also make clear to your lordships that, as with Common Ground in 2013, these claims were civil claims. They were brought in the context of criminal proceedings. The criminal proceedings were against the master. The only claims against the club were civil claims, and indeed the claims against the master were civil claims for compensation, albeit brought in the context of criminal proceedings.
I suppose if they turned out not to be civil or commercial proceedings, you'd be quite happy for other reasons.
Well, that's true, but I think unfortunately I would then have to face up to the fact that there is a European Court of Authority for saying that where there are civil proceedings that are brought in the context of criminal proceedings, they are nevertheless civil or commercial proceedings,
yes,
for the purposes of Brussels regulation.
Yes, right.
So much as I would like to have that further string to my bow, I fear I don't. So, the position with relation to the prosecution, yes, of course, if it was a pure prosecution, But whereas here, then the burden of the relevant song was that the states were entitled to civil compensation for the losses that they had suffered. It was those civil claims. In passing, very much on that song, Mr. Young made reference to claims under the Civil Liability Convention. As your lordships will have seen from Prestige number 2, then the CLC claims were not the subject matter of the decisions in that in those cases, because the CLC claims are claims for statutory compensation pursuant to international convention, which has been incorporated into Spanish law. There is, as Mr. Young said, a dispute that has been raised in other proceedings as to whether the claims in Spain were actually CLC claims entirely, in their entirety, as opposed to claims on the insurance policy, which is a question of the reading of the Supreme Court judgment that wasn't something that was an issue in the previous proceedings. But I don't think that that needs to trouble your lordships, because it's not relevant in relation to any of the issues with which your lordships are called upon to deal. And it's certainly not relevant to the issues of immunity with which I'm dealing at the moment.
Right.
The third point I was going to make is that, and this is a point that goes back to a point my Lord Justice Mayle made yesterday, and that is that, in a sense, any of the sections of the state immunity will do as far as the club is concerned. So if we are right in relation to any of the sections, then Spain does not have immunity.
I think we would be helped in due course to know if we were to be in your favour on any one of them, is there, so far as you are concerned, any necessity to decide either all or any of the others?
Can I see if I can answer that question now?
If you like.
So the answer to that question is that in relation to one of the sections, and that is section 9, then if, for example, and I take it simply as an example, if your lordships were to be with me in relation to section 3.1a, and were therefore to find that there was no immunity in relation to the various proceedings, nevertheless, in relation to section 9, in the context of the section 18 application, then it would be beneficial to the parties for the Court of Appeal to reach a decision on that point.
If we were to do that, would there be anything left for the arbitrator to decide?
No, because if, well, no, that's not true. Let me be more specific. The answer is, if your lordship,
Assuming we upheld
if
the
your
injunction
lordship
were in
was
your
to
favour.
decide that there was a binding arbitration agreement, then the arbitrator wouldn't have to decide anything in relation to his or her own jurisdiction. But that is currently the position anyway, on the basis of the first instance decisions of Mr. Justice Henshaw and Mr. Justice Foxton.
Does that mean that that point wasn't argued before Mrs. Justice Gloucester, or was that, has that been a live point in her arbitration?
The point in relation to the French arbitration is that the point has been argued. There are arguments as to whether or not the judgment of Mr. Justice Foxton, which was, as your lordships know, an unopposed judgment because France did not appear on that application, gave rise to an issue estoppel on the issue of jurisdiction. And there was the further question of whether or not it gave rise to an issue estoppel, she was satisfied that she did have a jurisdiction. If the position is that she reaches her own decision on jurisdiction, then that in turn, but the Court of Appeal has actually expressed no view on that issue, that would mean that the position remains as it would in any normal arbitration, whereby there would still be the possibility of a Section 67 application. If, on the other hand, the Court of Appeal had held that there was a binding arbitration agreement, although it would still be possible to bring a Section 67 application, it would be that much more difficult because on such an application it will be said that there is now a binding decision of the Court of Appeal on the very issue in question. If this court had decided that there wasn't a binding arbitration agreement, then by definition the question that would arise on a Section 67 application would have been determined by this court. So going back to your Lordship's question to me, then there are issues other than jurisdiction that arise before the arbitrators. And as Mr. Young has already pointed out in relation to the Spanish arbitration, and the same is true in relation to the French arbitration, there have been a number of issues of Spanish law which have been raised by the states and on which there has been evidence in each arbitration, as well as a number of issues of substantive English law relating to the remedies available to the club for breach of any obligation to arbitrate.
Yes, all right. Thank you very much.
But does that mean that the answer to my Lord's question is, on the hypothesis you put, if we were with you on 3.1a, you would want a decision on Section 9 because it determines the jurisdiction of the tribunals finally, and that would be a useful thing to have either way, useful to you if it goes your way and useful to Mr. Young either way, in determining the jurisdiction of both tribunals.
Yes, that's the way that both parties have put it to your Lordships in their skeletons.
Yes.
That in a sense, there are risks to both parties in asking the court for a decision on Section 9, but equally there are potential rewards to both parties in asking for such a decision.
Can I just raise something in relation to that? Normally, the courts are reluctant to decide in advance jurisdiction if all that is needed is a good arguable case, or if it's unnecessary to decide it, because of the competence of the tribunal and the general principle that in the first instance it's for the tribunal to determine its own jurisdiction, and then that can be reviewed thereafter.
Yes.
Is that a principle to which we should have regard in the particular context we're talking about?
Well, there are pros and cons to that argument, and sometimes it's an argument that is put. I'm thinking of, for example, Section 9 applications, where the opposite view is taken. In Section 9 applications, then the court takes the view that it should make its own mind up as to whether or not there is a valid and binding arbitration agreement, rather than waiting for the court for the arbitrators to give their view. In other areas, the court adopts the approach that your Lordship has outlined to me, and effectively says that it would be of assistance to the court to know what the tribunal's own view is as to its jurisdiction. Hence the principle of competence, which means that although the tribunal cannot decide upon its own jurisdiction with finality, nevertheless there are arguments which make it potentially desirable for the tribunal to do so, either because the tribunal decides it doesn't have jurisdiction, that may bring an end to the matter, or the other way around, or that whatever the tribunal decides, that may be of assistance, as I've indicated, to the court in reaching its decision in due course. So, I'm sorry to give a rather long answer to your Lordship's question, but I think, yes, the answer is it is a relevant consideration for the court to bear in mind. And if the position is that the court were to take the view that it is strictly speaking unnecessary to reach a conclusion on the jurisdictional issue, then those considerations are clearly relevant considerations for the court to have in mind.
I suppose under Section 32, the court will determine jurisdiction as a preliminary point, either if the parties agree in writing, maybe not agreed in writing, but you've both said it on the transcript, or if the arbitrator gives permission. Presumably, nothing has been said to or by either of the arbitrators about whether they would welcome or prefer not to have a decision on the point.
No, nothing has been said by the arbitrators.
Yeah. Okay.
My Lord, then the fourth point is the human rights point, and that is that if something we would say has gone wrong with the English statutes, or if they have been construed so as to give state immunity when no state immunity is justified as a matter of customary international law, then they should be construed differently in the light of human rights considerations, because state immunity is something which bars access to courts. Under the Human Rights Act, then access to courts can only be justified if the relevant bar is proportionate. And in Ben-Carbuche, the Supreme Court held that any bar to court which went beyond customary international law, i.e. the grant of immunity in relation to sovereign activities, was necessarily disproportionate. So I emphasise 3 points there. The first is that although it was put in terms of justifying an exception to immunity, actually it's the other way around, that it is for a state to justify immunity by reference to customary international law, and it follows from that that the burden is on the state to do so. Secondly, that customary international law in that regard it is defined by reference to the celebrated definition of Brownlee, as to say unanimity is not required, but a significant degree of unanimity is required. The third point I make is that this argument is very much an alternative argument. On occasions, then, Mr. Young seems to be suggesting that our entire argument in relation, in particular, again, to section 3.1a, was dependent on the decision of Ben-Carbuche. And one can see that that is not so, simply from a reading of Mr. Justice Butcher's judgment, as he found in our favour without ever actually considering Ben-Carbuche, simply on the basis of his reading of section 3.1a of the State Immunity Act. So, whilst I will take you to Ben-Carbuche and take you through that case, and I'm sure you've read the case in detail already, then one should not place excessive reliance on that, in that our primary case remains one which is tied to the wording of the State Immunity Act itself in relation to section 3.1a. What I do, though, say is, if and insofar as domestic drafting considerations come into play, then the background is important in that regard. One example is the example that my Lord Justice Popplewell gave from Ben-Carbuche when discussing the question of how the Act was structured. And my Lord pointed out that Lord Sumption rejected the argument that because of the fact the Act started with a general immunity and then had a series of exceptions to immunity, that was somehow important. And your Lordships will remember, no doubt, that the methodology of draftsmanship was something that was very much in dispute between the various participants in the European Convention, which led to the State Immunity Act. Some parties being in favour of the opposite type of drafting, where essentially you didn't start with a general statement of immunity with exceptions, but you started with a statement of when immunity was justifiable. then, well, I've made this point, I think, already. I just wanted to refer your lordships to the relevant passage in Carbouche as to what the test is for customary international law. It's a paragraph 31 of the report. It is a widespread, representative and consistent practice of states on the point in question, which is accepted by them on the footing that it is a legal obligation, opinio juris. And what I would say in relation to the materials that the states put in front of you at the moment is that those materials consist of a convention which is not in force. It's been stated by the Supreme Court on 2 occasions not to be declaratory of customary international law, in the Ben Carbouche case itself and in the Bottas case. And in addition to that, then the states have put forward a few examples of individual statutes from other countries around the world that fall very far short of establishing a binding practice of the sort necessary for the purposes of establishing the relevant immunity. So with that general outline,
Does this come down to who has the burden? Because I think Mr. Young was making the same point, that it's not enough to show the other way around.
well, what I was submitting is that Mr. Young is clearly wrong in relation to customary international law. He made 2 points, and as your lordship pointed out to him, then they were elided into one. One was that simply as a matter of statutory construction, because of the fact that there was general immunity followed by a series of exceptions to general immunity, the burden was therefore, because of that legislative technique, on the club to bring themselves within one of the exceptions. The second was when and if one gets to the question of customary international law, who has to prove the relevant rule of customary international law? My point is twofold. One is that what has to be proved is a rule of immunity, not a rule of exception from immunity, but a rule of immunity. And Ben Carbouche says the only relevant rule is sovereign acts. And my second point is that the burden lies on the states to show that the immunity is justifiable. So that is a burden. The third point is the standard by reference to which they have to prove that, and that's by reference to the standard I've just indicated to your lordships.
If on as a matter of ordinary domestic statutory construction, states would be entitled to immunity, it can't be a burden on them then to go further and establish that that's justifiable as a matter of customary international law, can it? It must be for you to raise.
Yeah, no, that's exactly the opposite of what Ben Carbouche says. What Ben Carbouche says is that because of the provision, the start point is the Human Rights Act. So you have to start with the proposition that the individual is entitled to access to the courts. The second point is that the grant of immunity is a bar to that access to the courts. The third point is therefore that that bar to access to the courts must be justified. The fourth point is that insofar as the bar is state immunity, that state immunity must be justified. And the fifth point is that that state immunity can only be justified insofar as it is consonant with customary international law. If it is not consonant with customary international law, then the statute in the relevant place has to be read down so as to make it consonant with customary international law, so as to mean that the provisions of the Human Rights Act are not trespassing.
Read down by throwing out sections 2 to 9 and simply reading section 1 to say so far as consistent with customary international law, which is the way Mr. Young put it, I think.
Well, yes, I wouldn't go so far as to say that. You'd have to look at each of the relevant sections, and you'd have to ask whether the relevant section was one which was justified by the principle of by the relevant principle of customary international law. So there might well be different principles of customary international law that have to do with the differing provisions within the State Immunity Act. All we're really concerned about here is 3(1)A for the purposes of this argument, because the argument in relation to the other provisions of as far as I can see, doesn't really involve considerations of customary international law.
I don't see how the burden can possibly be on the state when the Act provides that the court has to consider whether there's state immunity even when the state doesn't appear and is present.
Well, the answer, my lord, is the burden is on the state because the Act is not the relevant starting point. The relevant starting point is the Human Rights Act.
Then if the burden is on the state and the state isn't there and doesn't present any argument, then there is no obligation to consider statutory because they're not there arguing.
Well, no,
they can't meet the burden.
The court would then have to consider the relevant materials. So
But there wouldn't be anyone there to put them before the
court. No, but the court, the section is there in order to ensure that the court, of its own motion, considers whether or not the state
how
has immunity.
does the court consider it when there's nobody putting forward what the customary international law is?
Well,
must be obligation on the party asserting there is such customary international law.
But there would be
to adduce it.
There would be two ways of the court doing that. One is that obviously the party that is in front of the court would be obliged to provide the court with assistance in relation to that issue.
Why? It's an adversarial process. Why would they be obliged?
Because the court it's not an adversarial process in those circumstances because the court is under a duty itself to take the point itself. And the reason that the court is under a duty to take the point itself is because of the fact that the whole basis of state immunity is par in pare. The whole basis of state immunity is that a court is not entitled to sit in judgment on one state, is not entitled to sit in judgment on the courts of another state, unless it is satisfied that the other state is not immune from suit. So the court has to ask itself, is there in fact immunity from suit? Then the question would be, well, by reference to what test would the court ask itself whether there is immunity from suit? And your Lordship's question, I apprehend, is does the court say, well, it's up to you, it has to be up to you because the statute says that is the case, or is the case, as I would say, that because the statute has to be read in the light, as we now know, of the Human Rights Act, the court also has to address the question of whether the immunity that it is considering is itself consonant with the provisions of human rights. Because if it isn't consonant with the provisions of human rights, it would offend against the Human Rights Act, which are also binding upon the court, which is considering the question.
But this all arises by way of a process of statutory construction. Ben Cambush is simply, for present purposes, because we're not concerned with declarations of incompatibility, it's the application of Section 3, which provides you must read the statute so far as possible consistently with the Convention.
Yes.
So one would have thought that it would be for a person who invokes that aspect, that rule of statutory construction, to prove that the ingredients which make it applicable apply?
Well, my lord, what I can say, that's not what the Supreme Court said in Benkar-Booch. Because as long as the provisions of the Human Rights Act are trade in aid, then the question is whether the immunity from suit that is claimed is consonant with the provisions of the Human Rights Act. Because the Human Rights Act takes precedence over the state immunity. And the obligations of the court therefore has to read the State Immunity Act in a way which is consonant with the Human Rights Act. That's the result of the decision in Benkar-Booch. But as I've indicated, my lord, because this is very much an alternative argument on my part, I don't want to spend a huge amount of time at this stage of the argument, unless your lordship could find it helpful. But I apprehend that it may be easier to come back to it.
Well, can you just give me the reference and the paragraph number in the Supreme Court where they deal with burden of proof? That's all.
It's paragraphs 33 to 39. The other paragraphs will all in relation to the other point that I made is that the relevant rule is that it is only sovereign acts which are protected. The relevant rule is not that a state is protected or is immune except in relation to commercial acts. And that's paragraphs 37 to 52 of Benkar-Booch. So the Supreme Court looked at, if you like, the other end of the telescope. They say that the question is the immunity justified? The answer to that question is, it is only justified insofar as it is in line with principles of customary international law. And if one asks, well, what are the relevant principles of customary international law, the only immunity that is justified under generally accepted principles of customary international law are sovereign activities.
Frankly, Lord Sumption says in 36, if there is such a rule, the court must identify it and determine, etc. That doesn't really deal with the question of burden of proof.
Yeah, perhaps I can go and have another look actually over lunchtime and see if I can.
It may not. It's not the most central point.
Well, I hope not. But it is obviously important that I should take your lordships through that case, insofar as the case actually is, in any sense, decisive. Your lordships know my case is not decisive because we didn't ever need to get there for exactly the same reasons as the learned judge didn't need to get there. Because we succeed under 3.1a without the need to ever get it to Benkar-Booch. Before I then get to 3.1a itself, then I think I do need to take your lordship to a few cases relating to the award claims and the nature of the award claims in the light of some of the points that Mr. Young made yesterday. And as your lordships know, then the award claims are claims for failure to honour the English arbitration awards, i.e. the awards of Mr. Schaff. The starting point in this regard is the decision of Mr. Justice Aikens, as there was, in the Montesquieu. That is bundle C2, Well, the C1, tab 16. Just to set this in context, then I just invite your lordships to read through the heading so you can see how the relevant issue arose. You see, the issue for the court was whether the claim on the award was a claim arising out of the use of a ship within the statute, so as to justify an arrest. And the judge held that it was not a claim arising out of the use of a ship, because it arose out of the failure to honour the award, and the obligation to honour the award was distinct from the arbitration, the obligations in the charter party, which was the contract which related to the use of the ship. You can see that if we go to page 566. And from letters B to G. So again, if I can ask your lordships to read that passage. He then sets out his conclusions on that first issue at paragraph 22.
Just before we leave that,
Yes.
it may not matter at all, but I have some difficulty with the idea that the implied promise derives from the submission to arbitration of a particular dispute rather than the original arbitration agreement. And clearly that couldn't arise, could it, if one party took no part in the reference?
Well, I think that my answer to your lordship's question directly would be yes, it would, in the sense that there would still be two separate stages to the analysis. One would be the obligation at the outset to refer matters to arbitration, and then the second would be the reference of the individual dispute to arbitration.
But isn't the promise to be found in the arbitration agreement, which is, on a classic analysis, is a conditional mutual option as it's been described? Once the condition is fulfilled, namely there is an arbitral dispute which arises, then that can be referred, and if the option is exercised to refer it, the promise to abide by the result, I would have thought, is all part and parcel of the original arbitration agreement. Indeed, I think I've said as much in a judgment actually called the Seamaster in a bills of lading case. It may not matter, but I myself am more attracted by the idea that the promise is always in the arbitration agreement itself, rather than the submission.
Well, it may matter if the states took no part in the submission to Mr. Schaff, and the arbitrator was appointed by the court, and the states were simply standing by not saying anything at all. In that case, you would need to find any obligation, as my lord says, in the previously existing obligation to arbitrate.
Well, yes, but the logic of Mr. Justice Aikens here is that, and it is obviously a necessary part of the logic in his decision in the case, is that there is a distinct stage between the original obligation to arbitrate. Obviously, if you didn't have the original obligation to arbitrate, you couldn't have a reference. So the fons et origo, if you like, the obligation must be the obligation to arbitrate in the original agreement. You then have the intervening step of the reference of the particular dispute to arbitration pursuant to that obligation. And it's the reference of that particular dispute which in turn leads to the award. And it's the award that there is then an obligation to honour. And under this analysis, then the obligation to honour the award is separate from the obligation to go to arbitration in the first place. And it is an obligation which arises as a matter of law, and it is a matter of English law, which requires you to honour an award which has been rendered with jurisdiction.
I follow all that. We're just looking at what the source of the implied promise is, and speaking of myself, I find it rather difficult to find it in the submission. Mr. Justice Aikens says, and this I entirely understand, well, you have to prove the submission because that's the condition, and you've got to show you had an agreement to arbitrate disputes, that this was an arbitrable dispute that was submitted, and that there has been an award. Yes. Those are all the necessary conditions. None of that answers the question, where do you find the promise to abide by the ultimate award? And I think the classic analysis of what the nature of the rights and obligations which are imposed by an arbitration agreement are, namely the mutual conditional option that Russell and Boyd determined it to be, and I think Mr. Justice Phillips, Nicholas Phillips, also adopted, and which I adopted in the Seamaster case, all look at it as an obligation which derives from the original arbitration agreement, albeit that it's an obligation which is dependent on some conditions being fulfilled in due course, one of which is an arbitrable dispute, the next of which is a valid submission of that to arbitration.
Well, I certainly don't disagree, my lord, that the ultimate source of the obligation must be found in the obligation to arbitrate, which will be in the original agreement, or in this instance, in the equitable obligation to arbitrate. In response to my Lord Justice Nails, I would submit that the fact that somebody doesn't take part in a reference when that reference has actually been validly submitted, albeit by virtue of an order of the court, to arbitration, and that reference has ended with an award which is a binding award, which the courts have found to be a binding award, clearly shouldn't make any difference to the situation.
Well, if the implied promise is derived from the original arbitration agreement, then no problem. But if you adopt a contractual analysis and one party is neither offering nor accepting, then it's a bit hard to see that an obligation arises from the submission. I think it's simply the same point as my lord was making applied to the facts of this case.
Yes, it rather depends on what you mean by offering and accepting. In circumstances in which we look at the conditional benefits analysis, then the conditional benefit analysis requires somebody to take a step, which in turn imposes an obligation. There's not much difference between that and an offer and acceptance analysis, in my respectful submission, but that's the way that the courts have viewed it, at least thus far. I'm just showing.
Sorry, I held you up on paragraph 11. Where are we going next?
Showing you the way that Mr. Justice Aikens analysed it in the Bunfest, and he analysed it on the basis that I've showed you. You can see actually that in paragraph 22 and indeed 22, paragraph 22, he sets out his conclusions on the point. Obviously, the importance of is that and as he says, one, the claim clearly arises out of the agreement to refer to the disputes that have arisen under the Fairfield Charter Party. And then he says a claim on an award arises out of or is connected with the agreement to refer the particular dispute to arbitration or the agreement to refer to future disputes generally to arbitration. However, that agreement to refer to disputes is not itself an agreement relating to the use or hire of a ship. And he refers then to the general principle of severability.
In subparagraph 2 seems to say that, or to make clear that the point that my lord and I have been debating with you was not critical to his reasoning.
Yes.
Because he says whether it's the individual reference or the general agreement to refer, it still doesn't fall within the Admiralty jurisdiction.
I'm sorry, it's my fault. I should have taken you to this section first.
That's fine.
Obviously, the point with which he was concerned was simply the question of whether the agreement in question, in that instance, was one which related to the use or hire of the ship. And he held, no, it wasn't. Because the agreement in question was the arbitration agreement, which was a separate agreement from the agreement for the use or hire of the ship. So that was the Bunvesti. Then the next authority is the Amazon Group, which isn't C2. And that is at C2, volume 27. Volume C2. The relevance of this judgment is because it describes a particular judgment of Lord Justice Thomas, there was, describes the different methods of enforcing arbitration clauses, beginning at paragraph 5 of the judgment. Going through to the end of paragraph 7. your lordships will see that that's a very short, pithy, clear account of the two different ways of enforcing arbitration awards in English law. The first being pursuant to section 66, which was the statutory procedure brought in order to simplify matters, and the second being the action on the award, which was simply an action in court brought to enforce the promise to honour the award. And the award claims are just the latter, that's to say they are claims brought in court to enforce the promise to honour the awards. So when the learned friend Mr. Young said yesterday, well, the club had never brought an action on the award, then that's exactly what the award claims are. He has a different point, which is that it's no longer open to bring actions on the award because it's merger. Because he says effectively that having obtained a section 66 judgment, then we can't any longer go back and procure a judgment in an action on the award, because his argument is, well, there are two alternatives. You can't actually get one and then actually come back and seek the other. And I'll show you in a while judgment of the Hong Kong Court of Final Appeal, to which he's made reference on a few occasions, which says that you can do that. You can always actually come back and get a judgment on the award, as long as the judgment on the award is not inconsistent with the decision that you have already got. If it's inconsistent with that, you may have to make an election between the two. That's what happened in the Court of Final in the Hong Kong courts. They're actually take you to it in more detail. But there, essentially, what happened was that there was an order made for wasn't specific performance because the relevant obligation was not specifically performable under the relevant law, which was the law of the PRC. But there was an order made by arbitrators that a party should continue with performance of the contract. That order was then actually made an order of the court pursuant to the Hong Kong equivalent of section 66. Then what happened was that it transpired.
Must have been 103, presumably.
Yes, I'm sorry, but it's the equivalent.
Yeah.
The sort of short form procedure. What then transpired when matters came back before the court is that the defendants couldn't carry out the performance of the contract because shares in the relevant entity had been transferred unbeknownst to the plaintiffs to someone else. So what had been the intention of the parties, namely that one of the parties would buy the shares in an entity, could no longer take place because the shares in that entity had been transferred by the defendant. And in those circumstances, then essentially the Hong Kong Court of Appeal said, well, you can no longer get enforcement of the contract, but you can get damages for the failure to comply with the order to carry the contract out. And they drew an analogy with Johnson and Agnew. So where you get an order for specific performance, then actually the order for specific performance is not complied with, and you can then come back and say, right, well, I'd like damages for the failure to comply with the order for specific performance. That decision was upheld in the Hong Kong Court of Final Appeal in a court which included full assumption. There were other rather complex issues involving constructive trusts, the importance of which is they made clear that there couldn't be a constructive trust in that context because the contract in question was not specifically say, I'll take you to the case in more detail.
Can I just raise something that's in my mind while we're looking at these cases?
Yes.
In due course, I welcome a bit more assistance on what exactly is the content of the implied promise. Promise to do what? I noticed you characterised it a moment ago as the breach as being a failure to honour the award.
Yes.
The obligation in Braemar Oil Transport, quoted by Mr. Justice Akins, was talking about an implied term that the award would be fulfilled.
Yes.
Lord Justice Thomas here talks about an implied promise to pay.
Yes.
And all of these are obviously quite important when we're looking at a declaratory award. I'm not necessarily asking you to deal with that now, but if as we look at cases, there are passages which cast some light on that, I'd be very grateful if you refer me to them as we go.
Can I say at the outset, I don't think there's going to be any of the cases which actually answer your lordship's question, but the Hong Kong case is going to be the closest one to do so.
Right. Thank you.
Because in that case as well, the court had to consider the question of whether, where declaratory relief had been awarded, then further relief could be awarded, if you like, arising out of the declaratory relief. And the court considered a series of cases, including the Dalmia case, and including the Somertram case, and including a case of a couple of other English earlier cases. And the general principle that came up was that the court was able to fashion remedies to give effect to the obligations of the award. And so here actually, obviously the obligation in the award, it is a restatement of the obligation that already existed, namely to arbitrate the state's claims.
I see that Lord Hobhouse in the Associated Electric case uses the phrase damages for failing to honour the award. He doesn't, unfortunately, explain exactly what he means by that. I don't know whether that's the origin of the way you put your case or whether you've derived it from something else or your own inventiveness.
It is certainly one of the ways, one of the authorities from which we have derived under a case under ordinance is paragraph 13 or something, recollection. That's also cited in the Hong Kong case because that's the bit I think where Lord Hobhouse talks in terms of the award adjudicating and then the courts enforcing the adjudication.
Yes, it is. It's paragraph 9.
And the Hong Kong courts also referred in that context to an extrajudicial speech by Lord Muscle, which is quoted in Redfern and Hunter, which describes the relationship between the arbitrators and the courts as a bit like a relay race, where the battle starts with the courts, and so far as the courts are necessary to start the arbitration run, it's then passed to the arbitrators to adjudicate upon the dispute, and then it is passed back to the courts to enforce the decision of the arbitrators.
Mr. Young would say that you've now chopped the baton in half and given half to the arbitrators and half to the courts.
Of course, but or indeed dropped the baton several times in the agreement.
There's only one battle.
Yes. Okay.
I thought you'd be interested to.
Yes. All right. Well, we'll get to that case when you want to show it to us.
So going back to my Lord Justice Popplewell's question, then what we would say is we would say actually that the obligation in the contract, which is then actually restated in the award and in the judgment, again, is the obligation to arbitrate the state's claims. And what I should also make clear at this stage is it's very important that your lordship should concentrate on the obligation with which we are concerned in these cases and in this appeal, which nothing to do with the pay to be paid. It is all to do with the obligation to arbitrate. And on occasions, then, Mr. Young went off down side roads in which he relied upon decisions relating to the pay to be paid clause as somehow impacting upon the obligation to arbitrate. In so doing, he was with great respect wrong. He also said that what the club was asking for was the negative relief in relation to the pay to be paid clause. That is wrong, as your lordships can see from the awards. The club asked for positive relief, i.e. a declaration that the estates were obliged to arbitrate, and negative relief, namely that the club was not liable by reason of the pay to be paid clause. What we are here concerned with is the positive relief that the states sought and obtained, namely the obligation, the club sought and obtained, namely the obligation on the part of the states to arbitrate their claims, which is the obligation that the states have not adhered to.
When you say that the obligation in the contract was restated in the award,
Yes.
What I understand you to mean is it was declared as existing in the award. And so when you characterise the promise as a promise to honour the award, is it a mischaracterisation of your argument to say that you say where an award declares the existence of obligations, there is an obligation to honour the award in the sense of not acting inconsistently with the declared obligations, even whereas here it doesn't order any performance of those obligations.
The only caveat I would have there is that the form of the declaration in this case said that the states must arbitrate.
Yes.
So there was actually a positive obligation imposed by the awards.
But that's semantics, isn't it? Because what it should have said is the states must not bring claims other than in arbitration. Because they couldn't be positively obliged to bring claims.
They could have dropped the claim.
So it was, in fact, properly construed, it was a negative obligation.
Yes, well, but I think the point I was making is that it was an obligation imposed by the. Now, it goes back to the point.
Whether it's an obligation or maybe another question. But it was negative in content rather than positive.
Yes, I don't think I would dissent from that. It's certainly right that insofar as that effectively what it was saying is if you want to bring these claims, they have to be brought in arbitration. I think the point I was making was directed more towards Lord Justice Nails's question last week as to whether we say that the declarations were coercive. And it rather depends on what you mean by coercive. If I make clear what I say, I don't say. We didn't see an injunction. On the state of the law, actually, as it was at that stage, we couldn't have done it. The through transport case in the Court of Appeal said that you cannot claim an injunction against a non-party. That decision was overruled in the use of Senate theology. But that's what the law was at that stage. In addition, of course, the states say now that we couldn't have sought an injunction against them. That's one of the arguments in the arbitration and in the underlying claims, because they say we are a sovereign state, and Section 13 of the State Immunity Act prevents you from obtaining an injunction. They also say Section 13 prevents you in a particular way. And indeed, as we said in our skeleton, one might have expected and hoped that when that relief was obtained and was confirmed by the English courts in proceedings in which the states both participated, then the states would have adhered to the obligations that the courts and the arbitrator had held that they were under. In fact, of course, as we know, they didn't adhere to those obligations. They went on with their claims in Spain, notwithstanding the earlier proceedings in the courts of this country.
Is there a difference between an injunction and an order that somebody does not do something?
Well, that's a difficult question, my lord. That's a question that we on this side have debated on a number of occasions. There is at least one potentially positive difference. That's to say that a committal order would not, I think, issue.
But that might just depend on whether that's no answer, because that may depend whether there's a penal notice or not.
No, that's true. And I think my answer to your lordship's question is no, there's no difference. If in fact you're ordered to do something, then all an injunction is an order of the court that you should behave in a certain way.
So if you've accepted that you've not got an injunction, then all you've got is something that's purely declaratory and contains no, as my lord would put it, coercive.
Well, I think we're perhaps talking across purposes.
I think maybe difficult in definition of what's meant by coercive. I think that speaking for myself, I've been treating it as the equivalent of a judgment or order or award which orders something to be done or not to be done, as opposed to a declaration of what someone is under an obligation to do or not to do. And if one uses coercive in that sense, do I understand you to be accepting that this is a purely declaratory award,
Yes.
which is not coercive in that sense?
Yes.
Your cavilling is, well, it may have a coercive effect if you're right, that there's an obligation to honour, adhere,
Yes.
whatever phrase you use, i.e. not act inconsistently
Yes,
with
my
the rights or
cavilling is-
obligations so declared.
My cavilling is really simply by reference to the word must in the wording of the declaration, which does actually indicate that there is an obligation.
Well, it's a declaration as to an obligation that
There is an
exists.
obligation. Lord Justice Phillips was asking, well, is there a difference between a court ordering that you must do something and a court ordering an injunction? Well, in this instance, the court did order in the sense that it made the same declaration that the relevant party was obliged to do something or obliged not to do something, depending on which way you read the order.
Well, the court surely not. Suppose that the Section 66 judgment had been endorsed with a penal notice. It's not an injunction. Mr. Justice Hamlin's order was not an injunction. It was a declaration.
I'm not cavilling with that. My point in relation, in response to Lord Justice Phillips' question was, he said, well, if you accept it's not an injunction, doesn't it follow that you accept that it has no effect, no coercive effect at all? My point was simply, well, what it does, it states an obligation, and an obligation of itself is, it sets out what somebody is obliged to do. If you have said that somebody is obliged to do something, or taking my lord's point, not obliged to do the opposite, then, in a sense, the whole point of obtaining that relief is to ensure that they do not, the other party does not behave in the way that it has been stated they should not behave.
It's an odd scenario that where if you accept that you cannot get an order making of order for various reasons, possibly because of immunity, that nevertheless you can ask for a declaration which in effect has the same consequence, because you can in some way enforce what is declared as though it was an order.
Well, no. What you're in, depends on what your lordship means by enforce. What I said was, I didn't say that we could not now get an injunction. That's one of the issues that is.
Yes, but you didn't.
But what we didn't do is to ask for an injunction.
But effectively, you're wanting to enforce it now on the basis that it effectively can be regarded as an injunction.
No. What we want to do is to
Or
enforce
order.
it now by seeking damages for the failure to adhere to the obligation which was declared to exist.
But what obligation? If there was no order that somebody do something, what is the obligation?
The obligation is to comply with the contractual, quasi-contractual duty, which the contract imposes by reason of the doctrine of conditional benefit, which has been declared to exist by virtue of the award, and which has been confirmed to exist by virtue of the judgment.
Yeah.
So you're simply seeking the normal remedy for a failure to adhere to a contractual obligation, in this case a quasi-contractual obligation.
Yes. Is that a convenient moment, Mr. Hancock?
It is my lord, yes.
All right. 2 o'clock.
Rise.